G'day everyone, welcome to the third video in the 12th and final week of our Legal Ethics and Trust Accounting course. This week we're looking at the disciplinary outcomes if a practitioner fails to comply with their ethical obligations. So far this week we've divided those obligations up into professional misconduct, which is the really bad stuff, and unsatisfactory professional conduct, which is the bad stuff that's not the really bad stuff. In this third video, we're going to look at the various types of consequences that can be imposed on practitioners who are found to have committed professional misconduct or unsatisfactory professional conduct. I need to start though by making one thing clear. The professional consequences of misconduct have nothing to do with any other potential consequences of that same misconduct. So, for instance, if a practitioner was found to have stolen money from the trust account, this would certainly be professional misconduct and a penalty would be imposed for that conduct. But in addition, the practitioner would likely have to face criminal charges for the theft. In the same way, you might remember that the costs agreement between a client and the practice is a contract. And so if a practitioner engages in professional misconduct or in unsatisfactory professional conduct in a way that also constitutes a breach of the contract, then any disciplinary sanction is entirely separate from their potential liability in contract. Second, bear in mind, as we discussed in previous videos, that the sanctions for professional misconduct are focused on protecting the public, usually by preventing the practitioner from practicing. However, the sanctions for unsatisfactory professional conduct are focused on developing the practitioner so that their conduct in the future is more effective. Let's start with the worst sanction, striking off. Remember in week 3 we talked about admission? We talked about the fact that you are admitted before the court if you are recommended by the board and then admitted by the court. It makes sense as a result that if the board withdraws its recommendation or if the court withdraws its admission, then you can no longer practice as a legal practitioner. This is referred to as striking off because the practitioner's name is literally struck off the roll of practitioners. Striking off occurs when a practitioner has engaged in professional misconduct and where nothing short of removing the practitioner from practice will be sufficient to protect the public and maintain public confidence in the system of justice. So striking off is a last resort. It typically involves dishonesty. To highlight striking off, I want to refer to 2 cases. In a very old case called In re Brownsall, the practitioner was convicted of larceny for stealing a guinea, which was an amount of money worth a little more than £1. He was punished in accordance with the criminal law of the time by being burnt in the hand. He was later struck off. The court said, "It is on this principle that he is an unfit person to practice as an attorney. It is not by way of punishment, but the court on such cases exercise their discretion whether a man whom they have formally admitted is a proper person to be continued on the roll or not. Having been convicted of felony, we think the defendant is not a fit person to be an attorney." More recently, more notoriously, we have the case of Lawyer X, a criminal defence barrister named Nicola Gobbo, who was also a police informer. Ms. Gobbo provided information to police about her criminal defence clients, thus completely abrogating the sanctity of the confidential relationship between a practitioner and their client. The High Court said Ms. Gobbo's actions in purporting to act as counsel for the convicted persons while covertly informing against them were fundamental and appalling breaches of her obligations as counsel to her clients and of her duties to the court. At the time of this video, Ms. Gobbo has not held a practicing certificate for some years, and the Law Society in Victoria has commenced proceedings to have her struck off. A legal practitioner who's been struck off is entitled at a later time to apply to be admitted again. but as you can imagine, any such admission application would have the mightiest of hurdles to overcome. The second sanction is suspension. Suspension is used in circumstances where the misconduct was lesser than the level that would justify striking off, and where the court has some level of confidence that after the period of suspension, the practitioner will again be suitable to practice. This usually means that there has been a falling short of the required standards, but in a way that does not impugn the practitioner's fundamental suitability to practice in the profession. In a case called Ria Practitioner from 1984 in South Australia, the practitioner had removed money from the trust fund. But he'd done this in a way where he wasn't actually defrauding the clients. He was actually defrauding the other partners of the firm. It was argued that striking off was not justified because there was no fraud on the clients. The court disagreed though and struck him off anyway because dishonesty is dishonesty. The third type of consequence often applied to professional misconduct is a reprimand. Reprimands are given in circumstances where the conduct is sufficiently serious that it counts as professional misconduct, but where the conduct is isolated, or where the conduct is improper but nobody is harmed, or in any other circumstances where, looking at the circumstances as a whole, neither striking off nor suspension seem justified. The next sanction that I want to talk about involves the imposition of conditions on the practice of the practitioner. This is something that happens not uncommonly in relation to unsatisfactory professional conduct. Conditions imposed on practicing certificates can be wide-ranging. They might include a requirement, for instance, that the practitioner undertake additional professional development in an area related to their unsatisfactory professional conduct. It might include a reduction in the level of a certificate. So, for instance, a person who has an unrestricted employee certificate might be required to undertake a further period on a supervised practicing certificate. Or a person with a principal's practicing certificate might be required to drop back to an employee certificate. But really, these restrictions can be absolutely bespoke and crafted to meet the specific circumstances for each practitioner. The next two sanctions that I want to talk about both involve money. A disciplinary body can impose a fine on a lawyer, so an amount of money that the lawyer has to pay as punishment for failing to meet the appropriate level of conduct. In addition, a lawyer may be required to pay a compensation order under Part 4.10 of the Legal Profession Act to compensate the client for any fees that have been charged, and also to compensate the client for any financial losses arising from the unsatisfactory professional conduct of the practitioner. Often the firm's insurance won't cover any of this, and so the compensation money comes straight out of the firm or the practitioner's own funds. Now, regardless of what sanction is imposed, the sanction will be recorded on a publicly accessible discipline register. It can also be publicised in any other way that the disciplinary body determines or orders. So none of this happens in private. It's not about naming and shaming practitioners either. Rather, it's about protection of the public, putting the information into the public domain. So, this brings us to the end of the substantive material for this week. We've learned about professional misconduct, and we've learned about unsatisfactory professional conduct. We've looked at their common law origins and the current statutory position. And in this video, we've looked at the wide range of sanctions available to disciplinary bodies to ensure that the sanction fits the conduct. In the final video this week, which is also the final video for the course, we're going to look again in overview at the crucial significance of ethics in the profession to bring to a temporary close your education in legal ethics, which will continue during every CPD year that you're in practice. Just one more video to go.